Yo, it's your boy Jacob. We got a short one for you today. We're going over our recently filed memorandum of law in opposition to respondent's motion to dismiss. I'm going to just start this off and kind of set a new format for these videos from here on out and start with kind of just an overview and what we're trying to do. And then if you want to stick around and read through it, you can. Anyways, the update here is obviously on the motion in opposition to their motion to dismiss. In short, I applied for my cannabis retail business registration through the city. I had first priority under the city's own ordinance, and I met all the requirements under Minnesota state law and their own ordinance. Even so, the city council denied my application, and they haven't explained why. I filed mandamus action. That's what this video is about, is the mandamus case. As you can see, here's the case file number. It's all public information. You can look it up yourself, which is basically asking the court to compel the city to do what the law says it must do, which is issue my registration. The city wants the court to dismiss my case, arguing that their decision was quasi-judicial, which they claim puts it outside the court's jurisdiction. Now, here's the key point. The court has already said that the state law and city ordinance require the city to issue the registration. That means the city didn't have discretion. They had a ministerial duty, meaning a clear mandatory duty to act. Excuse me, losing my voice here. They had a clear mandatory duty to act. The city's motion to dismiss, as we saw in the other video, ignores that. They try to claim their decision was quasi-judicial, but there was no dispute, no evidence weighed, no findings of fact. They just refused to issue the registration. That's exactly the kind of failure a mandamus action is meant to address. So our argument is simple. The city ignored a clear legal obligation, and the court should deny the motion to dismiss. So let's dig into it here. You have the introduction, which again kind of goes over the background up until this point. Respondents have moved to dismiss, asserting that they made a quasi-judicial decision, and thus that mandamus does not lie. The court, however, has already found that respondents were required by state law and their own ordinance to issue the registration, and I had first priority under their ordinances, and that I met all the requirements set out by the Minnesota cannabis laws, and that the council's refusal to approve my application was a failure to perform an official duty clearly imposed by law. Respondents' motion is an implicit challenge to those determinations. Respondents assert that they are outside the jurisdiction of the court by having made a quasi-judicial decision to deny my cannabis retail business registration by declining to address the court's conclusion that state law and Albert Lea ordinance mandate the issuance of the registration. However, respondents cannot show that their decision was quasi-judicial. As a result, the court should deny their motion to dismiss. Factual background. Once again, super redundant. I'm not even going to read it. You know what? It's fun to read. July 17th, I was given my state license and applied for the retail operations endorsement. Same day, I applied for the city registration. The application came before the city council on July 28th of Albert Lea. I was the only one on the docket for that date, and the city had not issued any retail registrations for cannabis yet. The city council of Albert Lea failed to approve the motion to issue the registration. Watch all the previous videos if you want the in-depth overview of all of that. Legal standard. Subject matter jurisdiction in the court's authority to hear the type of dispute at issue and to grant the type of relief sought. The question of whether subject matter jurisdiction exists is a question of law for the court. A party may move to dismiss a claim among other reasons if district court lacks subject matter jurisdiction. In ruling on a motion to dismiss, the district court must accept all facts alleged in the complaint as true and construe all reasonable inferences in favor of the non-moving party. Argument. The court has already found adequate facts and has made adequate legal conclusions to require denial of respondent's motion to dismiss. The court has found that the law mandates an issuance of retail registration to a state-licensed cannabis retail business that meets a certain set of requirements, and that petitioners met all the requirements so enumerated. Under the court's ruling, respondents had a non-discretionary duty to issue the registration, not merely to consider issuing it. In my opinion, that is 100% factual, even if you read Minstat 342. Respondent's motion is rooted in the idea that their denial of the registration must have been either quasi-judicial or legislative. In doing so, respondents disregard the possibility that they had a ministerial duty to issue the registration, and the denial was an abdication of that duty. That possibility, seemingly the only possibility consistent with the court's prior ruling, is fatal to their motion. Respondents assert that Lund v. Minnesota State Colleges and Universities requires dismissal of this case. They are incorrect. Lund notes that for an administrative agency's decision to be reviewable by cert, it must be quasi-judicial in nature, and cites Maynard v. Canfield for the proposition that certiorari does not lie to review legislative or ministerial acts of administrative agencies. If, as this court suggested, respondents had a ministerial duty that they failed to carry out, their failure to issue the registration was not quasi-judicial at all. As Lund notes, one of the three indicia of quasi-judicial actions is that an agency conducted an investigation into a disputed claim and weighing of evidentiary facts. But respondents do not argue, and, at least in this posture, cannot show how their decision involved a disputed claim, or that there were any evidentiary facts weighed, or even that could be weighed under the prescribed standard. There does not seem to be, or ever to have been, a dispute that petitioner had priority for the cannabis retail business registration, and that they met all requirements for the issuance of that registration, and respondents do not show that they invoked any legal basis for denial of the application, made any findings of fact, or weighed any evidence. As a result, respondents cannot demonstrate that their action included all the essential indicia of a quasi-judicial decision. Under the court's ruling, the issuance of the registration was mandatory under state and local law. In turn, respondent's motion to dismiss must fail. Conclusion: the court should deny respondent's motion to dismiss. Signatures, dates, yada yada. Nothing too crazy here. Like I said, summed it up in the beginning to hopefully give this a different format. Let me know what you think. Do you like having the summary in the front and our opinions in the front? Or do you want them at the end or throughout it like I've been doing before? Let me know in the comments below. Overall, hopefully this kind of helps. This is a pretty solid point that might, keyword is might, be able to help other people in similar situations. But they really have to be similar because, as you can see, there's other precedent that has been established for other like type cases that would either give strength or take away from the strength of potentially too different of a case. Hopefully that makes sense. The point is not all laws are applied the same way because of all the different little variables in all of these cases and matters. Hit me up with any comments, questions, or concerns. I will do my best to answer all of them. And, well, it's still appropriate to say this. Happy holidays. I hope everyone is enjoying time with their loved ones and is ready for the new year. Again, best of luck to anyone else in this situation. I'm doing this to remind all citizens that we have rights and that the government cannot trample them. Good night. Peace.